Out of line, did she favor the prosecution?
Well, I'll tell you what, at that one part, and I know you and I disagree, but when the judge said before the defense case was over, George Zimmerman, are you going to testify? She was out of line. Every trial in America, the judge has got to wait for the end of it. I don't care that she's the judge. There's also a defendant, and it's the defendant's rights that is supreme, not the judge's rights.
Well, the fact that there are 6 women on this jury, let's talk about what you think the implication of that is, Jeff.
Yeah, it really is an interesting thing. First, that there's only 6 rather than 12. If there would have been 12, there certainly wouldn't have been 12 women. So just by Florida cutting this down
we have
to 6.
6.
Yes,
6
okay.
women. What does that mean to you?
Well, you know, I mean, let's be stereotypical about it. Women are not as confrontational as men. So I don't know.
Yes, they are.
You are. and some other women hosts that But I'll tell you what, the average woman is not quite as confrontational as a man, and I wonder whether they're actually confronting each other with their differences.
Joined now by defense attorney Jeff Gold and former prosecutor Courtney Pilchman, who joins us from Irvine. All right, we now know that the jury has come back, and the judge said to them, what specifically do you want to know about manslaughter? That was a couple of hours ago. Now, Jeff, they have not responded specifically what it is they want. What does that tell you?
Well, they might be afraid of the judge. That's one thing. Judge has been a little stern to some of the lawyers. But look, let's talk about what this means. Could they reach manslaughter? Well, if they find no ill will, that takes out second degree.
Well, I'm going to assume, excuse me, Jeff, and I'm going to assume right now that murder 2 is off the table, that the jury is going down the list as they would do in most cases, and that they've taken off murder 2, whether it's because of self-defense or ill will, and they're moving down to manslaughter. Courtney, would you agree with that? Murder 2 is off the table?
Absolutely. I totally agree with you.
Okay, Jeff, what do you think?
Well, what I was going to say was, if you take out ill will, that takes out second degree. If you take out self-defense, that leaves you with manslaughter. So there is a way they're going to just say manslaughter. Now, I'm not predicting that. On the other hand, they may just be confused by this archaic manslaughter law. This is not one of the modern statutes that talk about recklessness.
To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Trayvon is dead, and George Zimmerman intentionally committed an act or acts that caused the death of Trayvon Martin. He cannot be guilty of manslaughter by committing a merely negligent act or if the killing was justified.
Well, it goes on further, if you read it,
yeah.
To talk about what the justification might be. Heat of passion, provocation. If they find that this killing was a sufficient provocation, then...
Well, if it was in self-defense, and then, Courtney, isn't it a fact that at that point, he's got to be reasonable in his assumption? The question is, maybe it was self-defense, but they would have known if there's self-defense for murder, there's self-defense for manslaughter.
That's why
correct?
I said the only way you get to manslaughter is to say no ill will, that takes out second, that you say there's also no self-defense. You can get to manslaughter. I think they're working all night. They're working on whether it's going to be manslaughter. I certainly don't think this means a conviction. It could mean an acquittal.